Please, your seat. A lot of information item number 9 for an order list. Let this matter to come up after 4 weeks. I have yet to receive the instruction manual.
IA is for what?
Condemnation, Your Lordship.
Notice has been issued in the condemnation.
Lordship.
How many days?
490 days.
490 days. Yes. Do you have any serious objection in the condemnation?
My lord, yet to receive the instructions.
No. Are you seriously objecting to the condemnation? We can
Yes,
hear
sir.
this on merits. Unless you say that you have serious objection, you'd like to file your,
Yes, my lord.
you'd like to file your objection?
Yes.
Okay. On a request made by the Learned State Council, 3 weeks time,
Central.
Central government.
Learned CGC, 3 weeks further time is granted to file objection to the, to file objection affidavit.
March.
May it please your lordship. My lord, I beg to mention item number 11 on behalf of the appellants, my lord. This matter is scheduled to come up for objection hearing on the IA, delay condemnation aspect, my lord, not for final hearing.
Okay.
May I pray it be taken up on 12th of November, my lord?
No,
That's a Wednesday.
we'll consider the aspect of IA only today.
My lord, I have some difficulty today. That is why I was mentioning the matter with the consent of the other side.
Okay, when do you want?
12th of November.
Who's for the other side?
Mr. Rungsu,
Okay. Okay, when do you want, Mr. Barua?
12th November.
Okay. 3 N. Barua, Learned Council, appearing for the applicant online, has prayed for an accommodation due to personal difficulties. Para, Sri so Learned Council for the opposite parties does not object to the same para, as agreed upon by the Learned Council for the parties, list on 12th of November.
Obliged.
In the order column,
In the order column.
Your Lordship, I beg to mention item number 5.
Yes.
Your Lordship, I'm yet to receive the instructions here, so kindly grant me 2 weeks time, Your Lordship.
Other side? Okay. Are you for the state or the
Your
central?
Lordship.
Miss so Learned State Council prays for and is granted further 3 weeks time to obtain instructions / file affidavit in opposition.
Your Lordship, similar prayer for item number 4 also.
For all the council, other side informed.
Lordship, I am on behalf of the petitioner.
Okay.
Yes. On the last date also, the state as well as the union, they have short time to file their counter affidavit. Considering the fact that, Your Lordship, it's a habeas corpus petition.
We'll fix a date. We'll have a date. Okay. Miss so Learned Council for the state prays for further time to obtain instructions / file affidavit in opposition. Para. The aforesaid prayer has, however, been objected to by, what is your name?
P. Suren, Lordship.
P. Suryan, Learned Council appearing online for the petitioner. Para. Considering the above, while adjournment is granted, the matter is directed to be listed on. Yes, give a date, Mr. Suryan.
Lordship, on the next Wednesday, since DB matter is listed on Wednesdays only, so 1 week time may be given, Your Lordship.
1 week, will it be able to do it within a week?
Your Lordship, 5th is a holiday, Your Lordship.
No, his, no, 5th is a holiday, right? 12th,
Yes, Your Lordship.
12th,
Lordship,
12 November. Earlier case also we can have it on 12th November.
Much obliged, Lord.
Okay, the earlier one, 12th November. Item number 5 also 12th November.
This one with the mission, hearing item 14, I'm also responded.
Okay,
I have some personal difficulty today, the matter may be listed after 2 weeks.
1-4.
Yes, my lord.
Yeah, for the respondent. You, who's for the NIA?
I'm appearing for the NIN.
Okay.
Lordship, I have recently been appointed as the special.
Okay, will reflect your name.
Yes, my
Okay.
lord.
Sri Suensu Learned Council has submitted that he has been recently appointed as the Special Public Prosecutor NIA. Full stop. Para. Sri Suensu Learned Council for the opposite party has prayed for some accommodation. Para. List after 2 weeks. The name of Sri Suensu be reflected in the cause list.
Deeply obliged, my lord. Lordship, I beg to mention, hearing item 16, 17, and 18, due to some personal difficulties, I was unable to prepare for the hearing. As such, it may kindly be listed after 1 week, my lord. We consider up to 11.
16, 17, and 18, you are for whom?
I am for the appellant. No, I am for the respondents. The state is the appellant.
Okay. Here state, Sri Suensu Learned Council for the respondent number 1.
Yes, my lord.
1. Praise for some accommodation. Also heard Ms. Suensu Learned State Council, who has not objected to the same. Para. Considering the above, matters are adjourned to be listed after 2 weeks, after a week.
Yes, 1 week.
Deeply obliged, my lord. May I please, my lord?
This will be in 16, 17, 18. Huh? Yes.
May I please, my lord? My lord, I would like to mention item number 3, if you want.
Yes. Yes, you're for the state. Okay.
On the performer respondent.
Okay. What is your prayer?
My lord, my senior counsel is engaged in another matter today.
Okay.
You guys will be.
Okay.
If the matter will come up on 26.
That matter is more important than this matter.
No, my lord.
No, all matters are equal.
Yes, my lord.
So you should have come here.
My lord, actually, this matter was fixed on date 9 of this month. However, on date 9, the matter came up.
Okay,
And
well,
then-
okay, tell us the date if he's coming from Gauhati or what?
Yes, my lord.
Okay, well, tell us the date,
26 November.
26 November, madam. A prayer for adjournment has been made on behalf of the respondents, 32 and 32 to 34. 34 also perhaps,
Only 32.
32 and 33. But you are pro forma respondents, you don't have much of a, okay, doesn't matter. On the ground that the, no, don't say anything for a minute. Considering, don't say considering. Para. On request, list after,
On 26th.
list on 26th of
November.
November, okay, 26/11.
What should I?
This will be in item number 20 and 21. 20 and 20. Okay.
My lord, I would also like to make one request. My senior PG psychiatrist, his name may be deleted in WA7.
Where is his name? It's not there in the cause list. One KJ Sakya is there.
In the WA7, in the.
No, it's not there in the cause list. Have you seen the cause list?
Yes,
You
my
want-
lord. However, in the orders, his name is being reflected in the previous orders.
Doesn't matter. Who is it? How does it matter? He must have appeared in one of the cases, in one of these. If it doesn't appear, will not reflect his name. In the
But
cause
only-
list, his name is not there.
Is there in the first place?
Where?
KJ psychiatrist.
You are deletion for KJ Sakya, or you said PJ Sakya?
It's actually PG psychiatrist. However, it's written. KJ.
No, KJ Sakya is another council. He's not a senior council.
Lord, my lord, however, only PG psychiatrist was appearing earlier in WA6.
Let it be there. How are you concerned? Let it be there. We want an appearance. Okay.
West Bengal.
Please, Lordship, I'd like to mention item number 12 and 13.
12 and 13, yes.
Lordship, let the matter come up on 19 November as a fixed matter. On behalf of TGSC BTK,
Okay. 13 and? Only
12 and 13.
12 and 13. A prayer for adjournment has been made on behalf of the Applicant Union of India. Para, this matter is accordingly adjourned to be
19 November.
listed on 19/11. 12/13, yes.
May I please, my lordship. Item number 19. LCR has been received as per the order, if direction will be given to prepare for paper.
But it is for hearing.
Yes, Lordship.
Paper book not yet prepared.
Yes, not yet.
You are for the appellant.
Yes, I'm for the appellant.
Sri so learned counsel. I heard Sri so learned counsel for the appellant as well as. Who is appearing as PP? You are appearing.
On behalf of BC, Lordship.
And Ms. So appearing on instruction of Ms. so learned PP Nagaland. Full stop. The LCR, don't say LCR, the TCR. TCR have been received. TCR and small s. TCRs have been received. Office is directed to prepare the paper book expeditiously and thereafter list this matter for hearing.
Obliged, Lordship.
For motion from the supplementary cost list, item number 22.
May I plead, Lordship?
Yes.
Lordship, the instant matter pertains to the detention of the petitioner under the NDPS, PIT NDPS, Your Lordship. And accordingly, the petitioner is assailing the impugned orders dated 056/2025 and the impugned rejection order dated 07/07/2025 and as well as the impugned rejection order and the confirmation order passed by the detaining authority.
What are your grounds, Mr. Suryan?
Lordship, my ground is that the provisions of the PIT NDPS Act has not been complied while exercising powers by the detaining authority, Your Lordship.
What is the non-compliance?
Non-compliance is, Your Lordship, that is page 17 of my ground for that is clause B. Here, section 3, subsection 2 of the PIT NDPS, it says that after the passing of the detention order, the concerning authority, that is the state government, has sent report to the central government within 10 days. And in this instant case, that mandatory provision has not been complied, Your Lordship.
But this aspect was taken into consideration by when your application was submitted. And
yes, Lordship. Even while rejecting my representation, they have simply said that there is no valid grounds, but without specifying any reason as to why there was no valid grounds.
We'll issue a short notice. Since when you are in custody?
Yeah, Your Lordship, I was arrested on 24, Your Lordship, or 23 to 2025.
23/2.
Yes, Lordship.
Hard. And the other two matters, Mr. Suryan, similar.
Lordship, that is a different date. Item number this 26 and 27, they are analogous case. In that case, there were two.
23 and 24. This is 22, not 26.
Yes, Lordship.
22 and 23, yes. 22, 23. But the grounds of challenge is the same, are the same.
Lordship, and date 23 and 24, that relates with NDPS, and there also, while exercising these powers under the NDPS Act, mandatory provisions were not complied with, Your Lordship.
PIT and DPS.
Yeah, this one is PIT NDPS, and that item number 22 and 24, 23 and 24 with regard to NDPS.
How do you come in a rejurisdiction? Those are not preventive detention. How do you challenge in a rejurisdiction?
That is NSA under National Security Act.
You said NDPS.
NDPS, yes.
Lordship, I beg my apology, Lordship. That is NSA.
Okay.
Yes.
Yes, so we'll pass the same order. In the first, it will be NDPS, PIT NDPS. In the 23 and 24, will be NSA. Okay. Heard Sri P. Suryan, Learned Counsel, for the petitioner, who by means of this petition has put to challenge the orders dated so and so. Please see the synopsis. Okay. Okay. And it will be different for this. First is PIT NDPS, second NSA. Issue notice. Returnable, we give a date.
Lordship, minimum 3 weeks time.
Yes, we'll give a short date.
Lordship.
It has to come before a DB, so we'll have it on as 19th of November. It's a Wednesday, 19th of November. Madam, you have to take the instructions, sir. Ms. So-and-so Leonard State Council accepts notice on behalf of respondents 1, 2, and 3. Whereas Ms. Who's for Union of India? CGC? Any CGC? Oh, where, is he there in the court?
He was present, Your Lordship.
Okay. Whereas 3, so-and-so Leonard CGC accept notice on behalf of respondent number 4. You can also accept. Okay, no, I'll give, accept notice, extra copies will be given, so-and-so. Extra copies we served upon the Learned Council for the respondents within 2 days. Okay. List on. No, list on 20 or 19th. 19th, Mr. Suryan, 19th.
Lordship.
Okay. All same order, only the dates will be different and the act will be different.
For admission, item number 1.
Yes, Mr. Takamas, after a long time, how are
Yes,
you?
Lordship, fine, Lordship, I'm fine, thank you. Lordship, this Sumudu PIL relates to, Lordship, the Kohima.
Yes, who's present today? Some officer was supposed to be present.
Yes,
Lordship, actually, the executive engineer of the concerned area was supposed to be present here. But Lordship, when I conducted, there is a ongoing paint down strike. At the same time, the concerned officer is out of session, material crowd. So, we be allowed to appear on the next date. And lot more has to be submitted today.
You should have filed an application. That is not the purpose.
Yes.
Some strike is going on. This is a matter of grave importance.
Lordship, I agree.
Importance not for the court, importance for the people of the Nagaland.
Lordship.
Entire area has caved in.
yes. In fact, the road is closed.
At least you could have
For
filed an
last month.
application. There is an order. This,
The road is totally collapsed and
Yes.
closed for the last 3 months.
yes.
So we would like,
And lots of activities are coming in December.
yes.
And for that, Nagaland is so famous. You cannot prevent it.
Lordship, after the 24th, last sitting of the annual court also, there are so many.
No, what we are concerned is that you should have filed an application.
Lordship,
Court felt that his presence is required because to assist the court. It is nothing to do with any contempt or something, but his presence is required to assist the court. How do you solve the problem? And this
Lord-
PIL is going on since when? 2019.
Yes, 6 years.
And the road, I think, what is the kilometer? How far is it from Dimapur to Nagaland?
Dimapur to Kohima is 74 kilometers.
And that patch?
That patch around 27 from Chosumba, that is Chennai 172 to up to Liri.
27 kilometers.
Around 27 kilometers. And
So you need 6 years to get 27 kilometers repaired.
Lordship,
Lordship, here in this area, that particular portion, the nature.
No, that we understand, but
Yes.
there would be some remedy. Science have advanced so much. It cannot be that we don't have a road, we don't have the
Yes, yes.
mechanism, or we don't have the expertise.
Even at Chennai 172, now department has taken a water footing development there.
we have this,
Create a-
Lordship. My respectful submission, Lordship, since some other direction has to be issued to the NHIDC, because also, my lord, the road, my lord, is I should say in 4 packages. Package 1, 2, 3, that is 4-lane construction, TL Chutuma bypass. That is within the jurisdiction of the NHIDC. And the directors have been-
Correct.
And the 4th one, that is from Chutuma bypass, that is only 2-lane. It is the Nagaland PW Department, National Highway in Nagaland is maintaining that portion. So, Lordship, with regard to the presence and non-presence of the executive engineer, Lordship, appropriate order may be passed. But may I pray that we review the last order?
Yes, we have seen that.
Yes. So certain direction has to be issued and to like whether the direction is implemented or not. So kindly allow me to read so that.
We have gone through that order.
My lord, yes.
Last sittings order,
But then,
24th order.
only my respectful submission is kindly allow me to read so that every paragraph, if some more direction has to be issued, Lordship, we issue the direction accordingly.
But we thought that the officer would be present, some effective thing would be done today.
My lord, that
You're-
is only with regard to the last package, but for the first three packages, also certain direction has to be issued.
Yes.
That is why, lordship.
The directions which were in 24/9 does not,
Yes.
do not cover the first three packages.
My lord, it covers the
It covers.
first three packages also, that is why. My lord, only the last paragraphs, the last paragraphs cover, starting from lordship, only from paragraph, the last paragraphs are covered fourth package, but the first three packages are covered in the preceding paragraph.
You appear for the state
Lordship.
and are you appearing for the?
I'm looking for 1.9, and in the last model, I've been given liberty to file an additional.
Yes, that was,
Yes.
I filed it.
has it been brought on record?
I still want to, but I filed this one.
Because lordship,
Additional affidavit, your lordship, just looking on report, the damages caused to the road.
No, those part we can take care later. We are primarily concerned with how soon can the road be brought to its original shape.
lordship.
Damages, all those things can come later.
Then if that is so, lordship, we can fix a date. So to ensure
But,
that
the
the executive engineer
concern-
is present on the next day, we can hear everything in detail.
No,
lordship.
no,
That will serve the purpose.
Our concern is that next 50 is also a holiday.
Lordship.
Wednesday,
Yes,
we understand that on Wednesday the DB sits.
yes.
But if we say we can have a digression, we can have a sitting next week. Or on a date when the state council can give us an idea when this officer can be
Lordship.
present. And on that day, we can have a detailed hearing.
Yes,
We can
lordship.
take
That will
your
that-
opinion, your views into consideration and
Lordship.
pass appropriate orders.
That will be better. That will be better.
When do you expect the strike to be over?
So we, I have a difficulty to contact with the department because there's a strike, pin down strike is going on. So on our part also, it's very difficult to correspond with the office.
No, that is why we had asked you, when do you expect the strike to be over? You said a week. We'll not say anything within a week. We'll have a date after 2 weeks.
Yeah, to ensure that he's present,
Yes.
because without his presence,
And one thing we want to make it very clear. There should not be a stalemate till he comes.
yes,
It doesn't mean that in the meantime, you're not supposed to work.
exactly.
You have to put all your efforts and restore. And by the time he comes, he can come up and say that we have done it.
Yes,
That is the
Yes.
concern of all. It's not an adversarial litigation at all.
exactly,
In fact, it's a suo moto matter.
exactly.
We want the assistance of all of you.
Then let it be on 12.
How about the 19?
Malo, let it be on 19, we make an attempt on 12.
19th will be too late.
Yeah.
I think December 1st will be
Yes.
coming.
Let it be on 12.
Oh. 12, okay, 12.
12 DB is already.
Wednesday,
Witness,
we will have a DB also.
yes.
Put the appearance, heard, senior counsel, you appear as a
I'll
maker
make a lordship.
and all the appearances. Three, so learned, has submitted that though there was a direction of this court on the last occasion for appearance of the jurisdictional executive engineer and PWD so as to assist the court, due to some ongoing strike, the said officer could not be present, and he accordingly prays for another date, full stop. The learned, Sri Swansea Learned Senior Counsel, the amicus curiae, has expressed serious concern about the matter as the same is adversely affecting the larger interest of the state. Para. Considering the above, this court is of the opinion that a detailed deliberation would be necessary, which can be done in presence of the concerned executive engineer. Para. Considering the above, the deliberation of this matter is deferred with a direction to release the same on 12th.
Lordship, and to ensure that the concerned officer is present.
No,
on the
no,
next-
the direction for appearance of the concerned executive engineer shall be complied with on the next date.
Obliged, Lordship.
For admission, item number 2.
Yes, your lordships. Your lordships, in the two IAs as well as the main criminal appeal, there has been an intentional error that has been committed by way of typing Kohima instead of Dimapur. The
Doesn't,
signatures were,
okay, doesn't matter. What is the IA for?
your lordship, this is for condonation of delay of 235 days.
Worship, actually, I'm here on behalf of my colleague, Ms. Nared. She has difficulty today, so if another date, maybe
It's come for the first time or what?
Your lordship, this matter has been filed quite some time back.
Notice was issued
Yes, your lordship, in the month of August, this was filed.
for delay condonation in a criminal matter.
Yes, your
So we
lordship.
condemn the delay.
one thing is the affidavit. Now the appellant is in jail. And if you look at the opening of the affidavit also.
We'll not go into those technicalities. Criminal appeal, we'd like to have his matter heard in the by an appellate court.
My lord,
We'll condemn the delay. Okay, heard.
Joshua, your lordship.
Three, so and so learned counsel for the applicant, also heard Sri so and so. You appear on instruction of?
S. Mere.
She is the PP.
Yeah, I'm also a PP. No,
Then you can appear. Why are you appearing for somebody? You are an additional PP.
no, I am PP.
PP. The instant application has been filed under Section 5
Yes, your
of the
lordship.
Limitation Act 1963, praying for condonation of delay of 235 days in preferring the appeal against the judgment dated so and so, order dated so and so, please from the cost title, no? Passed by so and so. The learned counsel, by referring to the averments made in paragraph which paragraph?
Paragraph 11, your lordship. You know, your lordship.
Not 11.
My apologies, your lord. Paragraph 14, my lord.
Paragraph 14 has submitted that the delay has occasioned because of factors which were beyond the control of the applicant. First up, he has also submitted that the appellant should not be deprived of an opportunity, and not appellant, applicant should not be deprived of an opportunity of preferring, of having the appeal considered on merits. Para 3, since the learned PP has previously objected to the prayer for condonation of delay and has also referred to certain defects in filing the present application, including the affidavit. Full stop. Para. The rival submissions have been duly considered. Para. The settled law in the field of condonation of delay is that there should be a pragmatic and justice-oriented approach. Full stop. Moreover, the instant application has been filed in connection with a challenge of an order of the learned so-and-so court by which the applicant has been sentenced to undergo rigorous imprisonment. Full stop. Considering the above, we are of the opinion that the appeal should be heard on merits for which we are inclined to condone the delay. Full stop. The delay accordingly stands condoned and the application stands allowed. In the main appeal, you write, by an order passed today, that is so-and-so date, huh? In IA so-and-so, we have condoned the delay in preferring the appeal. Full stop. The appeal may accordingly be listed for admission. Admission, please.
Your lordship, there is another IA for stay also, my lord.
Stay cannot be there in POCSO matter. We have not been admitted.
Well, lord.
You can press your stay after we get the records.
Your lordship.
First, it has to be admitted.
Well,
Just kept alive.
your lordship. Obliged, your lordship.
For admission, item number 3.
Item number? Compliance affidavit
Not
filed.
Yes, Lordship,
Yes, your lordship.
When did you file?
Last week, my lords.
23. We received on 23/10/2025.
But
Lordship,
it is not there. Master. Compliance affidavit.
Your lordships.
Office note.
22nd of October.
But there's an office note of 27/10, it was not tagged with the records. We have the thing tagged with the record, then we'll consider.
Lordship. if,
But the copy has been served upon you.
Everything served, Lordship. We are ready. If my Lordship will permit us to take up the matter,
Well, we could have, but we don't have the affidavit before us.
it can be taken up after some time.
What-
I have already received.
What is the matter about?
This is a matter regarding land owner appointment, land ownership appointment. Lordship, here in Nagaland, we have a scheme where land owners who contributed their plot of land without compensation are given a grateful post to the land owners. There is a scheme. So here my plea before this honorable court that I am the land owner. It is an admitted fact that the respondent number 5
Why
is
was it rejected by the learned single judge?
on the basis that we have taken 2 landowner appointment.
Already.
Now that is this is the reason why I am before this honorable court. Lordship, they are saying that we have taken 2 landowner appointment. They have the respondent government has annexed in their affidavit in opposition the map where the executive engineer's office Atoizu and subdivisional office Atoizu are annexed. It is about 2 kilometers afar. So there is no dispute that Chopini clan, like Mijimomi, there is a clan system. So Chopini clan owns, they are the landowners of subdivisional office. And in between 2 kilometers or so, there is executive engineer office. So that is, and it is an admitted fact by both the parties that Ayami clan are the landowners of executive engineer office, whereas Chopimi clan is the landowners of subdivisional office. That is clear. Both the side have admitted. Now what has happened is, Lordship, the respondent number 5 also has admitted and admitted that, yes, I am not a landowner. I'm not a landowner, but since I happen to be from Ayami clan, there are 50 or lakhs of Ayami clan. Since I happen to be from Ayami clan, I was appointed. That is what they claim. Here the question is, the scheme is only for land owners, not that I am a Jimomi. All the Jimomi gets the right to be appointed on a landowner post, even between
But the ownership is on clan basis or individual basis?
It is individual basis, but then the 3 Chopimi clan, 3 individuals donated their land. It is a joint donation for a big plot of land. So they are saying that the single judge, learned single judge, deny me the appointments, stating that I have already availed 2 landowner appointment. Here I'm saying that there are 3 landowners. One already got it in our Chopimi clan. One already is appointed. That also by approaching this honorable court. Under the direction of this honorable court, 1 got appointment. That is, it is annexed in my petition. The second one, Srimati Bokatoli, they have annexed in their compliance affidavit. Is also on the basis of land ownership. She approached in 2018. She approached this honorable court, and the honorable court directed the respondent government to consider her case within 2 months. 2 months. However, that was never considered. So in 2023, that person is gone. In 2023, I applied on a general category. application. Landowner here in Nagaland Lordship, anytime when a landowner submits a representation, the application itself will say that appointment on landowner basis. That is how the application. So the application itself is general category, and she sought for appointment in 3 subdivision, whichever subdivision. Then she was appointed not on landowner basis. My lord will kindly, if my lord will kindly peruse the.
What about the report? Yes. Oh. Affidavit is defective. It cannot be brought on record. No court fee.
Dear affidavit.
Yes.
Lordship, my sincere apologies.
You get it rectified, we'll have it after
My
this.
lord. My sincere apologies, Your Lordship, I wasn't.
You should take care of this kind of small things.
Hey.
We could have, see, this matter is yet to be admitted. And considering the facts involved, we could have resolved at the admission stage itself.
Yeah, Lord.
Not a
Exactly,
very
there's
big
not.
issue. Either we agree with the learned single judge or we disagree. We could have taken that, but you have that affidavit. And first you have to rectify. Simply serving on the other side will not do.
My lords.
Defective affidavit is not an affidavit. Okay.
Lordship, they can do it, and can it be taken up at 2?
2 may not be possible. We have.
Lordship, I have to go on journey before 1 AM, 1 PM, Your Lordships.
So that was the reason of not having the court fee.
No, my lord, I cannot blame my juniors for this, but filing part, it's mostly taken care of by
No,
juniors.
you
and I
have to
wasn't
take,
aware of
you have
that.
to take the
Sincere
blame.
apologies, Your Lordship.
You have to
It's
take
my
the
fault.
blame.
I'll take the
If
responsibility.
some
Your
good
Lordship.
work has been done by you, the juniors can be appreciated. But if bad work is done by junior, you have to be blamed.
Yes, Your Lordships. My sincere apologies, Your Lordship. But as far as the argument is
okay.
concerned,
Oh,
course,
no,
we couldn't be.
No,
taken up today, but yes, Your Lordship.
without hearing you, we'll not take any
Yes.
Yes, Your
decision.
Lordship. My lord.
Do an affidavit of compliance has been stated to be filed by Sri J. Saki, Learned Counsel for the respondent number 5, comma, office note dated 27/10/2025 has reflected that no such affidavit has been filed, para? On an inquiry done, comma, it appears that though the affidavit was presented, comma, it is lying defective on the court fee issue. Para?
Your Lordship.
Let the defect be rectified and the matter be listed on the sitting of the division bench, on the next sitting of the division bench.
Lordship, next sitting will be
12th.
Justice, Mrs. Wailong Kumar will be sitting, so.
She'll not be able to take up. She cannot take up the matter.
Yes.
On the next sitting of the division bench.
My lord. Your Lordship. Oblige, Your Lord.
Obliged, Lordship.
For orders, item number 6.
Lordship. May I
Yeah.
please, Your Lord? Lordship, actually, I have received instruction from the principal counsel, Mr. N.K. Muri,
Yes.
to appear on his behalf. And Lordship, I have been instructed to adjourn the matter. Since he is busy in his personal matter, so he has instructed me to adjourn the matter and to leave the matter after 4 weeks, Your Lordship.
A request for adjournment has been made by Sri P. Suryan, Learned Counsel appearing online on instruction of Sri N.K. Murray, the Learned Counsel. Para. Also heard Sri Swensu Learned PP, Nagaland, full stop, para. List, on request list after 4 weeks.
Lordship.
For orders, item number 7.
Lordship, the return of service of notice upon the respondents is still awaited, my lord. As such, it may kindly be listed on 12th of November.
Okay. Seen the office note dated 27/10/2025, as per which service report is awaited. Full stop. Heard, Sri so-and-so, who has submitted.
My name may kindly be
No,
referred.
no, wait,
Auspicious.
that's so-and-so who has submitted that he has been recently appointed as the special PP NIE.
My lord,
Full stop. List after 2 weeks along with service report.
my lord.
Para, the name of Sri so-and-so learned special PP be reflected in the
My
contract.
lord, if a specific date can be given on
12th,
12th of 11,
List on 12.
12th of November.
For-
Keep your pledge.
For orders,
Same order, my lord.
8, same, office notice same.
Yes, my lord.
Same, huh?
Keep your.
for orders, item number 10.
I is for
Delay, your lordship, 35 days.
35 days,
Yes, sir.
coming for the first time. No,
No, lordship, second time. On the last petition.
notice was issued,
Yes, your lordship.
notice not issued. Oh,
Notice
notice has
issued,
been-
lordship.
Yes, who was appearing? Correct, no was not filed last time.
For respondent number 1, I have the instructions to appear.
And the others? Four. Who are the other respondents, madam?
State, your lordship.
State.
Yes, your
All the respondents are present.
Yes, your lordship.
Are you objecting to this 35 days? You're objecting, but we'll record your objection, but we'll condemn the delay. Okay. Heard Miss so-and-so learned counsel for the applicant who has filed this application under section 5 of the Limitation Act 1963, praying for condonation of delay of 35 days in preferring the appeal against the order dated so-and-so, passed in WPC so-and-so. By drawing the attention of this court to the averments made in paragraphs 4, 5, and 6, the learned counsel has submitted that the delay has occasioned because of factors which were beyond the control of the applicant. Full stop. Para. Also heard 3 so-and-so, all for respondent number 7, who has, however, objected to the prayer for condonation of delay. Para. An application for condonation of delay is required to be considered in a pragmatic and justice-oriented manner, as technicalities should not come into the way of dispensation of substantial justice. First of all, we have also noted that the delay is not inordinate, but of 35 days. Para, considering the above, the delay of 35 days in preferring the appeal is condoned. Full stop. Para, I stands allowed. In the main appeal, you write an order passed today, that is, give the date. In I-129 of 2025, the application for condonation of delay has been allowed. The appeal may accordingly be listed for admission.
My lord, I may be directed to give a serve of copy of the appellant.
You give a copy? Ms. so-and-so learned counsel for the appellant is required to furnish copies of the appeal to the learned counsel appearing for the respondents.
Lordship, if the appeal may be admitted by hearing me today, your lordship.
Appeal today, normally we do not do. Is there any urgency in here, admission?
Praying for stay, your lordship.
What is the impugned order about?
Lordship, here in the impugned order, your lordship, the learned single judge had directed the respondent number 1 to be appointed in the post of medical career. So what we are saying is that in a vacant post, usually there has to be advertisement where all the eligible candidates has to be applied. And I'm an aspirant, your lordship, for public employment.
But normally, what do you say?
No, my lord, the day is the delay is condoned.
Yes.
Let the other matters be heard in the other day, so that if need be, I mean, file objection to that. Because I've not-
Writ appeal, there is no requirement of filing any pleadings until and unless some new facts are brought in.
And I have not received the copy of the appeal memo as well as the IA for stay also. I have received only
I
a
have
copy
not-
of the.
I've not
I have
applied for special, I've not filed any specific IA for stay. It's in the appeal.
Let me be given the opportunity.
No,
to go
let
through the appeal memo.
them have an
No,
opportunity. It
then-
will not be
yeah.
proper. Okay, on 12th.
On 12th, your
On
lordship.
12th. If it was something extreme urgent, we would consider it.
For hearing, item number 15.
Yes, Mr. Jamir, how are you?
Good.
After a long time?
Yes, very.
What is this matter?
Lord Chief, this matter relates to the appointment of about 1,000 police personnels. And the writ petition, as many as 13 writ petitions have been filed, where they have sought for termination of our services and to issue a direction to the state respondents to advertise the post.
You are the beneficiaries.
And
your appointments were put to challenge.
Yes.
And successfully challenged.
As of now, as many as 13 writ petitions were filed. Out of that, 12 writ petitions pertains to the constables, numbering about 935 and so. But the present writ appeal confines only to few petitioners, that is 36 in numbers, who are sub-inspectors and assistant sub-inspectors. 38 was there, but again, two.
Madam Jimami, you are for the writ petitioners.
Yes.
Your petitions were allowed.
Very much.
And the state, who is representing the state? You are supporting the appellant. You are supporting the writ petitioners. Who are they? Okay, you are supporting the writ petitioners or the appellant? You are in a doldrum now. Whom to
Lord
support?
Chiefs, I am putting a question which do not have an easy answer, Lord.
That is why you are putting the question. We have to extract an answer. Who has the role of the decision making? 225.
The constable are concerned.
Madam, what were grounds of challenge?
Yes, Lordship, for the constables, they went to Supreme Court already, grounds of challenge.
Your grounds of challenge in the writ petition.
In the writ petition, they were appointed through better.
Oh, advertisement. Then,
That is the only issue, Lord.
then how do you overcome? This is a major issue.
Lord Chiefs,
You take part in an open advertisement.
police department is such a department. We cannot predict what will happen today, tomorrow. Today, it is very, very peaceful. Tomorrow, we never know. Some law and order problem may crop up, which may compel the department to resort for urgent recruitment like that.
Was there any such eventuality assigned in your appointment that because of extreme urgency, we do away with the process of
In the
recruitment?
exigencies of public services, we were appointed. Now, so far as the constables are concerned, they have taken a different approach altogether. We are not on that. And the purpose of filing the writ appeal, the grounds which we have taken in the writ appeal is also, we are different and not similar to that of the constables. So far as constables are concerned, there is a notification of the government 77/1976, which says that all the posts should be advertised invariably.
What
So
post
far
are you?
as the sub-inspectors are concerned,
You are sub-inspector.
there is, yes, sub-inspectors and some are assistant sub-inspectors. There is no recruitment rules for the constables as well as the sub-inspectors. and our service conditions are governed by the Nagaland Police Manual. So far as the constables are concerned, that is different. In the year 2004, the state government has issued a notification exempting the police department from that notification of 7/7/1976, which requires advertisement. Because as I was mentioning earlier, police department, it may so happen that the urgent recruitment may be compelled by the situation to make appointment. So the Director General of Police has been allowed, permitted to make appointment. In other words,
But Mr.
appointing
Jamir,
authority
Mr.
was
Jamir,
given.
if we respond, immediate response, a situation may require urgent
Appointments.
appointment. But can those appointments be of permanent nature?
The Lordship.
Or
it
will
depends
it be an
upon the-
appointment which is directly connected to the situation? Taking
only the
advantage of a situation,
situation-
you cannot have a permanent
Only the
appointment.
situation will check. So far as sub inspectors are concerned, a frivolous writ petition has been filed. Why I'm making that submission, Lordship?
We can
Recently-
we take this for disposal then.
We are on that. One clarification, Lordship.
Yes.
They went to the constables similarly situated, on only they are SI, UBSIs and constable. They were appointed at the same time, In 2019, only 207 were advertised. That is for ladies, Mahila. Otherwise, all others appointed through backdoor. In fact, this is the first time in Nagaland history where 207 Mahila were advertised. Besides that, till date, this is the first time coming before this honorable court challenging the backdoor appointment without advertisement. Otherwise, it has become the system of the rampant system of the government. Lordship, what has happened is these constables, they went to Supreme Court and the Supreme Court dismissed the SLP. They did not interfere with the learned division bench order. Now, after that, they came down. This constables, they filed appeal before the Honorable Gauhati High Court, the division bench. The matter was taken up on 23rd.
But you said the SLP was already dismissed?
That's
Now the SLP was filed against the order of
A single judge, okay.
That was, and then, so appeal was filed by the company, the petition connected.
Oh, writ petition.
Okay.
on 23rd.
Yes.
No, if we have a look at the order, we'll find, we'll know.
Lordship, now, this morning, I have asked for CTC. Now it is applied and it is going to be procured today, and they send me only the last page and the first page. And I have sent my junior to photostat it. It will come just in the meantime. What has happened is that on 23rd, Lordship, this clarification from the Supreme Court, since filing of the writ petition, they have been saying the same thing since January, after the SLP was disposed. Lordship, what clarification is there to see about it? Now, the other day, what they have done is.
I have only one copy, Lordship. I have highlighted as my official copy.
Yes,
That's one.
it was.
That is the order of the division bench of this honorable court. But all these orders pertains to the constables. And the date of order is also different.
But Mr. Jamir, we can express our mind
Lordship.
that whether it's constable or ASI or SI, we
Exactly.
cannot do away with the requirement of having an open advertisement for recruitment in public service. There is no
That is there.
there is no other second opinion on this. public employment has to be done openly, transparently, fairly, giving all eligible candidates an equal opportunity of participation. That is what we want, and that is what the law wants.
To
So
do that,
if you want to make a classification between or attempt to make a classification between constable and ASI, we may not be too interested in going to that aspect. Yes, there may be a classification, but that will not do away with the requirement of having an advertisement or recruitment process for inducting them into the service.
out of the,
And if you are emphasizing on the aspect of the situation thing that it might require exigency, that exigency cannot be an exigency of permanent nature. If there may be a urgency tomorrow to today, immediately we induct persons, but the urgency goes, the matter ends. But in the garb of an urgency, even a bona fide urgency, we cannot have a permanent kind of a recruitment induction.
I may be allowed to direct a little brief background, how the litigations
Just a minute.
proceeded from. I believe they have committed a mistake by approaching the Honorable Apex Court directly instead of approaching the division bench, the constables. But then.
At times you're too enthusiastic at times people are over enthusiastic. They approach straight to the Supreme Court.
Now, Lordship, so far as constables cases are
Okay,
concerned,
let us make some notes.
it was,
Try to have this matter dismissed with the drum connected. And these were constables, the IA?
yes, it was, the cases were also heard on different dates.
And the IA was for what?
They have filed for vacating the status quo order. And in this application also, there are so many defective pleadings. In the coast handle,
I'm not.
they have not implemented three applicants who were the respondents in the writ appeal. They have not approached this honorable court because two petitioners, they have served notice to the petitioners among themselves. We are respondents in the writ proceeding, up to the writ proceeding, because after the order was passed on 20th September 2024, it was published widely in all mass media. That time only the two petitioners came to know that they have filed a case. Two petitioners. So they served a legal notice that how I have not filed the petition, but that came to our knowledge after we filed the writ appeal. Therefore, a privileged writ petition has been filed, and under TF hearing on 26th of September, because our case has been heard after 5 days after the judgment in the constable's case were passed. By relying on the order passed in the constable's case, our case was also decided. And a basic difference, one important difference, in constable's case, affidavit in opposition was filed by the state and by the private respondents as well. No affidavit in opposition was filed in respect of our case, the present writ appeal. In the constable's case, the learned advocate general made the concession before this honorable court that we have taken a decision to terminate the services and we will proceed for advertisement, but some sort of a relaxation may be granted to us, for which I will discuss with the government and I'll inform this honorable court. That was the concession made by the learned advocate general. Lordships are well aware that the possession of the Advocate General is an exalted one. So normally, honorable courts also accept the concessions made by the learned Advocate General. So that was done in respect of the constables. And keeping in view of all this, the order was passed in the constable's case. And the cases which were relied by this honorable court was on three important cases. One is Suresh Kumar, which was in respect of Bihar, where the appointment of about 2,000 constables were challenged. In that case, that is also in the police department. In that case, concession was also granted on physical requirements and other tests. But no concession was given in our case. Secondly, in constable's case, the learned Advocate General has made a prayer. Please grant us concession. But then that was not given. Basing on the case of Ajoy Debarma, lordships are well aware about the case in Tripura where about more than 10,000 teachers were appointed. Ajoy Debarma and Tanmoy Nath. In these two cases, it reached Supreme Court several times and came back. There, concessions were not, basic qualifications were not given. Why? On the ground that the teachers are nurturing the future of the nation. Therefore, there cannot be any relaxation on the basic qualification and the Right to Information Act 2009 and the NCT Act of 2003 do not prescribe and permit to relax the basic qualification. That was the principle laid down in these two cases. But here in our case, it is not the basic qualification, only the basic, some requirements. Basic qualification, class 8, first 10, first, yes. They have all of them, they have this. So the ratio which has been laid down in Ajoy Debarma and Tanmoy Nath's case has been, with due respect, misapplied in this particular case also, because there is a vast difference between the basic qualification and other additional qualifications.
Let us have a look at the impugned judgment. I think that everything will be clear.
Yes. Before coming to that little background, I will not take much time, Lordship.
Yes.
At least we want to file affidavit in opposition in the case so that we will bring all this before the honorable court, because there are some petitioners who have not given the consent to file the writ petition, but writ petition was filed.
Mr. Zamir, see, we are in a writ appellate jurisdiction. It's concurrent. The aspect of you not giving a fair opportunity of contesting the case, that part will be over by the pleadings which you have made in the appeal. You have filed an appeal, you have supported the appeal pleadings with an affidavit, we'll hear you. There's no question of remanding back the matter to the Honorable Single Judge just to give you an opportunity of your pleadings being filed. Your pleadings are before us.
Lordship.
It's a concurrent jurisdiction, intra-court appeal will consider your pleadings.
Knowing fully well that in a writ appeal, no new facts can be admitted. That is why we have not brought any new facts.
Yes.
We have not introduced any new facts in the writ appeal.
No, Mr. Jamil.
Lordship,
Mr. Jamil, there'll be a difference.
Lordship.
No new facts by whom? By parties who were before the Honorable Single Judge.
Lordship.
Now you say that you are not before the Honorable Single Judge. So your version was never placed before the Honorable Single Judge. You get a chance to place your version only before the division bench,
Lordship.
which you have done.
No, Lordship.
The appeal is by you?
Even it, appeal I have filed.
Yes.
But by filing the writ appeal, whatever facts were there, only those things were incorporated because I cannot introduce new facts in the writ appeal.
Why not? You can take leave of the court. You file all your
Lordship can permit me to file affidavit in opposition so that I can file.
No, if you think that the facts which you want to place before the court is still not before us, you can pray for leave. We'll grant you leave to file an additional affidavit supporting your appeal.
I may be allowed to file affidavit in opposition.
Yeah, not an opposition. Additional affidavit supporting the appeal.
Lordship.
supporting the
Yes.
grounds of appeal.
Lordship.
And in that additional affidavit, we'll definitely have to give a liberty to the, mostly to the petitioners, writ petitioners, to file their response. Madam?
Lordships.
Lordship, I have filed even for vacation of the status quo order.
Is there a
Because of-
status quo order?
Yes, because of that, it has been continuing and to be factual before this honorable court. It was fixed for hearing on many occasions, and this wanting to file this affidavit, Lordship will kindly appreciate that this case was placed under the outcome of the constable case, and it was not taken up. Their previous advocate pleaded before this honorable court that since the fact of the case similarly situated, it will be placed for 7 months. They were given time to file their affidavit in opposition in the writ petitions. But they say that since it is the fact of the case, circumstances is all the same, they are not going to file, and it will be placed under the outcome of the writ petition.
Just a minute.
Constable case.
We have seen the order sheet. This prayer of yours at this stage, we don't think we'll consider that prayer. We'll go ahead with the hearing.
Which?
We'll go ahead with the hearing.
And one clarification, Lord.
This has been pending since 2024.
Yes.
And there, this court has taken into consideration all the facts and circumstances placed for hearing. We'll have it for hearing.
Lordship, during the hearing of the writ petition, because the order in the constable's case was passed on.
These are all matters of merits. You argue, we'll consider everything. We'll consider everything. We've just gone through the order sheet. The number of days this matter have been taken into consideration and it's fixed. There are observations that no adjournments will be given.
Exactly.
There's an order.
There have not sought even a single adjournment up to that order.
No, there's an order of status quo pending. We'd like to have this matter hearing to be heard. Please proceed with the facts.
Indian order, Lordship will find
Page.
at page 382. It starts from 387.
What is this order of 29/2024 by Justice Barua?
Yes, that is at page
That we have seen 343. That is not the impugned order.
343.
Which is the impugned order?
Indian order is 383. That is 26/9/2024.
Honorable Justice Manish Chaudhary.
Yes.
Okay.
343 is constable's case,
Yes.
and this is sub-inspectors and assistant inspectors.
Yes.
On that day, two cases were disposed of. One is constable on 26,
Yes.
and one is ABSI.
So this is impugned now.
Yes,
Four,
yes.
410-2024.
No, 482. 387 is the impugned order.
Yes. No, 387 is the Indian order.
370, yes,
26,
correct.
And this order has been based in the earlier order of 20th September 2024, which is at page 343.
Please read the impugned order. 387.
Heard, Ms. Seth Jamami, learned counsel, assisted by
You can skip this first part.
Let us start from
Two.
paragraph 3.
Yes. No, two.
Two. Oh.
In this.
In this writ petition, the petitioners 15 in numbers have assailed the appointments made in favor of the respondent number 6 to 45 as Sub-Inspector of Police, Anam Branch Sub-Inspector of Police, Assistant Sub-Inspector of Police, Instructor Havildir in Nagaland Police by the state respondent authorities on different dates in the years 2019, 2020, White Order of Appointment, Annexure, so and so. 3. The main ground to assail the order of appointment of the respondent number 6 to 45 is that the state respondent authorities had appointed the respondent number 6 to 45 without undertaking any valid process of recruitment and without publication of any kind of advertisement. It is the case of the petitioners that they are unemployed indigenous youth and are eligible to participate in a recruitment process undertaken as per the recruitment rules framed for Sub-Inspector of Police, unarmed Sub-Inspector of Police, Assistant Sub-Inspector of Police, havildars. The petitioners have sought setting aside and quashing the appointments of the respondent number 6 to 45 on the ground that the appointments were in complete violation of principles embodied in Article 14 and 16 of the Constitution of India. When this writ petition was listed on 19/9/2024, the writ petition was directed to be listed after disposal of a page of writ petitions, that is 189 of 2022 to 199 of 2022. The judgment in respect of which was already reserved after conclusion of hearing. After disposal of the page of writ petitions, number so and so, by a common judgment and order dated 29/2024, this petition is listed today for concessions. Mr. Sanctum, Learned Additional Advocate General Nagaland, representing the respondent number 1, as well as Mr. Chamir, Learned Counsel, representing the respondent number 2 to 19. This is not me, but another Jamir, TV Jamir, have submitted that no counter affidavit on behalf of the state respondent has been filed in this writ petition, as in the page of writ petitions involving similar issues. That is the constable's case, others are mentioned. A comprehensive affidavit in opposition on behalf of the state respondents was filed, and the stance taken in the said comprehensive affidavit in opposition would also cover the issue involved in the instant writ petition. This is the concession lodge. They have submitted that the said page of writ petitions was disposed of by a common judgment and order dated 29/2024. They have also submitted that as there is no difference in essence between the facts and circumstances obtaining in the said page of writ petitions, writ petition number so and so, and the present writ petition, the observation and directions made in the common judgment and order dated 29/2024 would also govern in this writ petition. The Learned Counsel for the respondent number 6 to 45 has also submitted in similar lines, adopting the submission of the Learned Single State Counsel, and no counter affidavit has been filed on behalf of the respondent number 6 to 45. 6. Ms. Sumumi, Learned Counsel for the petitioners, has submitted that the observations and directions made in the common judgment and order dated 29/2024 passed in the page of writ petition number so and so will be applicable on all fours in this writ petitions. From the statements made in writ petition and the annexures appended to, it is noticed that by an order number so and so, respondent number 6 was appointed as. These are all with regard to the appointment. Let us skip this. Let me continue from paragraph 8, that is page 390. The prime contention raised in the page of writ petitions was the state respondent authorities during the period from January 2018 to October 2019 made appointments of 935 number of constables in Nagaland Police without making any kind of advertisement, and those appointments were made through backdoors. It was contended on behalf of the petitioners therein, who were similarly situated like the petitioners herein, that by making such illegal appointment without following the principles laid down in Article 14 and 16 of the Constitution of India, the petitioners herein were denied the benefit of participation in the recruitment process despite being eligible. From the command judgment and order dated 29/2024, it is noticed that the Learned Advocate General Nagaland, during the course of his submission, had fairly submitted that the state ought to have gone for advertisement prior to making the selection and appointments of the private respondent therein. While submitting so, it had been urged on behalf of the state respondents that it was not a case that the private respondent therein were not qualified or did not meet the eligibility criteria to be appointed as constables in the Nagaland Police. It was further urged that since the private respondents had rendered their due service to the state, their appointments ought not to be looked as illegal appointments merely because of the fact that there was no advertisement. During the course of their respective submissions, learned counsel for the petitioners as well as the learned counsel for the private respondents had met submissions on the aspects of granting relaxation and various counts to them. If the court could find that the appointments made in favor of the private respondents were illegal and liable to be set aside. In the batch of petitions, number so and so, an affidavit was filed on behalf of the state on 28/2024, wherein it was indicated that one of the relaxation which the state of Nagaland had in their mind for extending to the candidate was age relaxation. Apart from the age relaxation, the state of Nagaland indicated in Annexure A of the state affidavit dated 28/2024, the other criteria where relaxations were envisaged. The learned single judge, after consideration of the manner in which the appointments of the private respondents in the batch of petitions so and so had been made, on hearing the learned counsel of the parties, after perusal of the materials on record, and after examining the legality and validity of the appointments of the private respondents, for the principles embodied in Article 14 and 16 of the Constitution of India, has found the appointment of the private respondents therein illegal in absence of any kind of advertisement. The learned single judge has also made.
Just a minute. Yes.
May I continue?
Yes, please.
Page 391.
Yes.
The learned single judge has also considered the aspects of relaxation sought by the sides of the petitioner and the private respondents. The said batch of petitions number so and so has been disposed of by the command judgment and order dated 29/2024. Inter alia, the following observations herein above. Accordingly, this court therefore disposed of the instant batch of petitions with the following observations and directions. 1. The appointments which have been challenged in the instant petitions, that is 935 posts of constables who were appointed during the period from January 2018 to October 2019 by the state of Nagaland without advertisement are all set aside in quash. The appointment orders enclosed as annexures referred to in paragraph 3 of the instant judgment are set aside in quash. The state respondents herein are directed to take steps for holding fresh selection of 935 posts of constables by issuance of advertisement in newspapers which are well circulated in the state of Nagaland. The said selection shall be held in accordance with law. 3. The process of selection be completed at the earliest and preferably within 6 months from the date of the instant judgment. 4. The private respondents herein whose appointments have been set aside by this judgment would be eligible to participate in the fresh selection process. 5. The upper age limit of both the private respondents as well as the petitioners herein shall be given relaxation. However, there shall be no relaxation in the matter of basic qualification as well as departmental physical criteria mentioned in Annexure A of the affidavit dated 28/2024. This court had rejected the concession relaxation as sought for in terms of Annexure A of affidavit dated 28/2024. The private respondents may be allowed by the state respondents to continue in service for a period of 6 months from the date of instant judgment until such time fresh appointments are made pursuant to the selection directed herein above, whichever is earlier. Then, Ms. Imomi, learned counsel appearing for the petitioners, has submitted that the fact situation obtaining in the batch of writ petitions, number is so and so, is similar to the fact situation obtained in the present writ petition, and as such, this writ petition shall also be disposed of the same observation and directions. On a query made by this court, Mr. Sanktam, learned additional advocate general Nagaland, appearing for the state respondent number 1, and Mr. Chamber, learned counsel appearing for the state respondents number 2 to 5, on the point where there exists any distinguishing feature in the manner of appointment of the present respondent number 6245 from the manner of appointment of 935 no sub constable, which was the subject matter of the command judgment and order dated 29/2024. They have fairly submitted that there appears to be no distinguishing features in the manner of appointments in the two sets of appointments. The learned counsel appearing for the other respondents noted in paragraph number 1 above have not also pointed out towards any distinguishing feature between the two sets of appointment. It has been settled by a long line of decisions of the Honorable Supreme Court of India and of this court that an appointment made without any advertisement in any selection process and reviews does not meet the requirement of Article 14 and 16 of the Constitution of India, as the same deprives all other eligible candidates from submitting their candidates and from participation in the competitive undertaking for filling up such a post. One of such decisions is State of Odisha and Anadras versus Mamata Mohandi, reported in 2011, 3 SSC 436. In the said decision, which is also referred to in the command judgment and order dated 29/2024, the Honorable Supreme Court of India has observed us under. I believe this we can skip.
Yes.
I'm reading from 11.1394. In Vinod Kumar Gupta and others versus Ramashram Mahato and others reported in 2005 4 ECC 209, the appellants were appointed as class 4 posts. It was found that they were appointed in grade 4 posts without issuing any advertisement in any newspaper and without adequate notice and fair opportunity to others who might have applied. It did not appear from records that the appellant's appointments were preceded by any selection procedure and review at all. It has therefore been held that the appointments were not made in a bona fide manner despite directives to advertise the vacancies in the newspaper. After setting aside the appointment of the appellants, a direction was made to issue fresh advertisement for filling up of vacancies of class 4 posts. In such scenario, it has been observed by the Honorable Supreme Court of India that the continuance of the appellants in service cannot be allowed merely because they had been found working in grade 4 posts for the last 15 years, as the same amounts to condoning a gross irregularity in their initial appointments. 12. It is admitted case of the parties that the orders of appointment of the respondent number 6 to 45 were made without any kind of advertisement and without following the principles which emanate from Article 14 and 16 of the Constitution of India. As there was no advertisement, the said act had deprived all the eligible candidates, including the petitioners herein, to submit their candidature for the vacancies in question. Such action on the part of the state respondent authorities leading to the appointments of the respondent number 6 to 45 are found in clear violation of the principles enshrined in Article 14 and 16 of the Constitution of India. 30. The law is well settled that a coordinate bench follows a decision of an earlier coordinate bench. If a coordinate bench does not agree with the principles of law and ensured by another coordinate bench, the matter can only be referred to a larger bench. But no decision can be arrived at contrary to or inconsistent with the law laid down by the coordinate bench earlier. As no distinguishable feature is found between the facts and circumstances obtaining in the present writ petition and the facts and circumstances obtaining in the batch of petitions number so and so, this court is of the considered view that the observation and directions made in paragraph 36 of the common judgment and order dated passed in the batch of writ petitions number so and so are also applicable in the case in hand. Such view of this court is also notified from this submissions of the learned counsel for the parties, including the learned counsel appearing for the state respondents, authorities, who are at consensus at item on the facts that appointment of the respondent number 6 to 45 were made in a similar manner like 935 number of appointments in the post of constable in Nagaland Police, challenging in the batch of writ petitions number so and so, which are disposed of by a command judgment and order dated 29/2024.
Yes.
With the observation of directions quoted above. In the above facts and circumstances obtained in the same case in hand, the present writ petitions is disposed of with the following observations and directions.
Yes, we have read the directions.
Okay. Now,
These directions are almost same
Yes.
of the directions of
Yes.
29/2024 at
Yes.
paragraph 391,
Yes,
page 391.
yes, Lordships. Now, two things I would like to bring before
Please.
the Honorable Court.
Hmm.
The principle which has been laid down by the ethics court, that is the law of the land, so we accept that. Following the same principle, the ethics court have also equally laid down the laws which can be considered at the time of filing a writ petition. That we cannot just pick up one judgment and forget the other. That cannot be. No doubt, admittedly, there was no advertisement. And the ratio laid down in the other cases like Mamata Mohanty, starting from Boma Divis and all that. Lordship may have seen over the years, there has been some deviation from the main direction and some sort of concession with regard to the irregular appointments have been observed in series of cases. The distinction of illegal appointment and irregular appointment. And we can at best say that these appointments can be treated as irregular appointment, where this honorable court as well as the ethics court can also cure. Number one. Two, the law which has been laid down for non-compliance of Article 14 and 16, that is a law of the land, so we have to respect that. We should be abide by that law. Equally, with regard to the maintainability of the writ petition should also be taken into consideration by this honorable court. Here, I have a very vital point. The writ petition which has been filed in respect of the assistant sub-inspectors and sub-inspectors. We are not grouped together with the constables. Constables are 935 constables. That case is different. Their nature of work is different. Our nature of work is different. Nature of appointment is slightly different because of the fact that in the year 2004, the Director General of Nagaland has been given permission to make appointment in the exigencies of services, Lordships. That is one. Secondly,
in 2004.
another vital point.
No, in 2004.
Yes.
What are the, please repeat.
I have to go to page 26.
What is there?
This is with regard to the relaxation and delegation of power to the recruitment of police department, Lordship.
Okay. Relaxation can be given.
Yes, yes. Power of recruitment of UPSI and ASI, an armed branch sub-inspector and assistant sub-inspectors.
What is the relaxation?
Relaxation says that in relaxation of the regulation 3A and 1 of the Nagaland Public Service Commission, limitation of functions, third amendment regulation to 2001, notification by the department's notification dated so and so, the governor of Nagaland is pleased to delegate to the Director General of Police the power of recruitment of UPSI, ABSI in the Nagaland Police under the Police Department with immediate effect. The Director General of Police will conduct the recruitment through a selection committee consisting of representatives of Home and PNR departments. So that is the one where the Director General of Police have been given some power to make recruitments, because as I was mentioning that the exigency of service may demand some.
Is it there that the requirement of advertisement, it can also be done away with?
We follow the Nagaland Police Manual. There it's in the role in respect of sub-inspectors, it's in the role 8.
Rule 8.
Yes. Direct recruitment of sub-inspectors. It
Yes.
doesn't specify and say anything about the direct recruitment.
No, we have read rule 8. What is there? What do you want to urge? Direct recruitment for sub-inspector. DGP or an Inspector General of Police shall constitute an interview board for direct recruitment of SI. The board shall constitute. What do you want to submit?
The appointments were made by the Director General of Police.
Yes.
So it doesn't, the in the exigency of service, the police department, TGB can make appointments. So
is it
gives
there?
power to the Director General of Police to make appointments.
Is there any reflection in these rules of your submissions that in exigency of service,
Without
yes, the general principles, the
Normally,
procedure
it
can
will
be laid down?
mentioned only in the appointment orders, not in the advertisement.
No, since you are trying
Not
to
in
make out a case that a power has been vested with the DGP or the IGP to make appointments on certain exigencies, it has to be prescribed in the rules directly, because this will be a slight diversion of the.
Besides this, there is no other recruitment rules,
Okay.
either for a constable as well as the
SI,
sub-inspectors.
okay.
Now, another very important feature, writ petition was filed by 15 petitioners, out of which
Hmm.
2 have not consented for filing the writ petition, which we came to know only after filing the writ appeal. So a frivolous writ petition has been filed, and due to non-filing of affidavit and due to serious communication gap between the client and the counsel, this was not brought to the notice of the Honorable Court at the time of hearing on 26th of September 2024.
You did not contest the writ petition.
I have contested, but Lordship may kindly see. There is a very interesting story. Out of the 40 respondents,
Yes.
2 persons who were appointed through competitive exam, after 2 advertisements, they were also implemented as party respondent whose appointments were challenged by the petitioners. 2 persons who were selected through competitive exam, through an open advertisement. They were also implemented as party respondent, but they were not aware that their appointments were challenged, which led to the filing of a review petition by these 2 persons after the pronouncement of the judgment, 26/9/2024. They came to know because it was published widely in the media.
Why they did not contest the writ petition?
They were not aware.
No, they're not being aware will not be the answer.
That is why
They may choose not to contest.
there was a serious communication gap between the counsel and the client.
But you are not representing those 2.
Yes, sir. Okay, nothing to
That
do
is
with
not
this
your case at all.
Nothing to do with this case.
Lordship, what I'm trying to project is.
No, you are trying to project a case that they did not approach the court with clean hands.
Correct.
They implicated persons who were also inducted by a properly recruited process.
Yes.
They have included persons as petitioners who did not even consent to file the writ petition.
Yes.
But what is the prejudice caused to you? You had contested the writ petition.
No, first thing first, Lordship, yes.
We take out these 2 petitions. There are 2 petitioners who did not consent. Let us take them out.
Correct.
We still have 13 left. You have to contest the 13.
That is why, Lordship, whatever is coming from your Lordship's side
Yes.
is perfectly all right. And I'm on that. When we are following the law laid down by the Apex Court,
Correct.
it is the fundamental principle of maintaining, considering a writ petition.
Yes.
Whether
we may put it in a very precise
the writ
term.
petition is maintainable or
Mr.
not.
Jamir, we can put it in a very precise term. Your argument is that they had approached the court in not a bona fide manner, not with clean hands.
Yes.
And therefore, the question of maintainability would also arise.
It happened raised.
Yes, arise. Did you raise the question?
No, in the writ petition, I did not raise. That is why, Lordship, there was serious communication gap between the counsel and the client, and Lordships are well aware.
Which counsel? Which counsel?
Another counsel, not me. I was not the engaged counsel.
No.
Counsel of representatives.
We don't look at you as Mr. Jamir or Mr. Jimomi or Ms. Jimomi. We look at you as a counsel who is representing a particular party.
Yes.
Today you are there, tomorrow your colleague may be there. But if we are concerned whether your clients were represented, they were.
They represented the only.
No, we appreciate your arguments that the approach to the writ court, the court of equity was not
Yes.
by clean hands.
Actually, first thing first, that ought to happen, considered whether the writ petition is maintainable or not.
But that was not raised before the single judge.
Just one clarification, Lordship.
No, we'll come to you.
Okay.
We'll get all your chance. Yes.
Now, in view of serious communication gap between the council and the client, the concession was made by the council at the time of hearing the writ petitions.
Yes,
That the other judgment, that is 20th September 2024 judgment, will cover this case as well. That was due to the serious communication gap. And I would say that with due respect,
Did you file any complaint against the council?
no, Lordship. Rather, I should go by the advice given by the council. And there, as I was mentioning in the initial stage, the Learned Advocate General has made a concession
Yes.
in their case. We have taken a decision to terminate and we have taken a decision to advertise. Only one thing, that age relaxation, the relaxation may be given. That was not given, except age. Because age relaxation, Lordship will find in most of the series of cases, even those cases which the learned single judge has relied upon, in the constable's case as well as in the sub-inspector's case, age concession has been given. And the main reliance made by the learned single judge in the constable's case was in the Ajay Dibarma's case and Tanmoy Nath's case, which is from Tripura. There, the council also said, in the event of issuing a fresh direction to advertise the post, petitioner may be allowed, but no relaxation should be given. That was the prayer made by the council for the state. Here in our case, the Learned Advocate General has pleaded before the Honorable Court that concession may be given. And in fact, on 8th of August 2024, this Honorable Court has permitted the Learned Advocate General to come with the manner of relaxation. And what manner you want the relaxation, please bring. But then, when it was filed on 20th September, it was also not considered. At least by virtue of serving the department for the last 5-6 years, even including the COVID pandemic time, some sort of a relaxation ought to have been given.
What kind of relaxation? You tell us.
Physical requirements and other, for example, running. Running, if it is requirement is 1 minute or 3 minutes, at least 2.5 minutes, that the proposal has been already placed on record. What kind of a relaxation was required?
Now, how has that relaxation got to do anything with the length of service which you have rendered?
In the event of
you seek for a relaxation which has got a direct connection with the length of service or the experience which you have gathered.
Lordship,
maybe by serving for 5 years, you have become more fitter.
Since
you can run within half a minute.
Since in respect of the constables, the decision was, concession was made that we have decided to terminate and we will advertise.
Yes.
That is the reason why the relaxation was sought for.
No, you tell us, as a counsel officer of the court, what kind of relaxation would you want us to incorporate in the direction so that no prejudice is caused to your clients? We may consider it. What kind of relaxation? Tell us.
Physical relaxations.
Well, how has it got to do with the connection with your serving the department? If it's given to you, why not to the others?
Chip.
No, your relaxation has to have some connection.
Out of the appellants,
yes,
there are few women.
Yes.
Appellants also.
Yes.
Some are busy with the child, small kids.
Yes.
And then some are pregnant, like that.
No, that will be an individual problem which the respondents are also be facing.
So similarly,
you can file an application.
After working for 5-6 years, now I cannot run as fast as like a fresh candidate who is young in age.
You should run faster. You are a police personnel.
Police personnel, that is in respect of constable, that is applicable.
SIs are not required to be fit.
SIs, they are more on the investigation part. There are more than 600 cases where the cases have been charged.
You are not required to be fit.
I'm fit, but then
You got to be
I will not be as fast as the fresh candidates who are 4 or 5 years younger than us.
See, age relaxation is something which is connected to your rendering 5 years, or you have already in fact 5 years have gone, but that doesn't have any connection with your fitness. Fitness is a requirement in the police. Anything which is reasonable we'll still consider.
Lordship. And that discretion,
Anything which was submitted by the Advocate General and which was not considered.
and in respect of the present appellants, there are more than 600 cases where it is charge sheeted. At this stage, if their services are terminated, then think of that situation also, Lordship.
Can this be a ground for interfering with a dismissal order? That I was connected with a investigation, if I am out.
So far, we have not been dismissed. We are.
You are still in service, Mr.
Yes,
Jamil.
Lordship.
Still continuing. And Madam is after you. Yes, state. Anything else substantial, Mr. Jamil? If I think you have covered everything.
Lordship,
We have
legally,
we have understood your case.
if we are to go legally, Lordship, with regard to the interpretation of the judgment which has been relied upon, there is a vast difference, Lordship.
Yes, sir.
The ratio laid down in those cases and our cases.
See, we can respond to you immediately. The nature of services, there may be a difference. The service conditions may be different. The principles which governs them as a public servant may be different. But the aspect of entry, induction, there cannot be difference.
I would say that this may be at best treated as a regular appointment.
That way,
They possess the requisite qualification and all that. You were appointed against sanction post.
Whether induction without an advertisement may be treated as an illegal or irregular. We'll answer that.
My learned friend has branded as spectre, but I should boldly say that I entered through the front door only, not the back door. And ratio laid down in the Ajoy Debarma, Suresh Kumar, and then the Jammu and Kashmir case, these are all illegal appointment without possessing the requisite qualification. They were appointed. They were appointed when they were not selected. Again, from the selected candidates, appointments were not given, but under recommendation of some ministers or commissioner or secretary, appointments were made. So it was treated as a legal appointment. In fact, that is correct. But our case is not that. It is at best a regular appointment. So in the event of interfering with the appeal,
yes,
Lordship may give the discretion to the state government in what manner they can consider giving in view of our services. Lordship.
Yes. Mr. John.
May I please, Lordship?
Yes. Here for respondent numbers?
Respondent number 2 to 5, Your Lordship.
Yes.
The Home Commissioner, DGP, IGP, Your Lordship. Now, in the earlier writ petition 189 of 2022 to 199 of 2022.
Yes, constable case.
Which relates to constable, Your Lordship. I was assisting the learned Advocate General, Your Lordship. But here, for state, Mr. L.T. Sanctum, additional AG is appearing. I am for respondent 2 to 5, Your Lordship.
But the decision-making process is by you, 2 to 5.
Lordship.
State is the nodal department, is the main. Okay.
The only grievance against respondent number 2 to 5 against me by the appellant is the concession which I have made before the learned single judge to the effect that no affidavit is necessary because the issue involved in the earlier writ petition 189, the common judgment, that will cover the present case, Your Lordship.
Yes.
And the concession made was on the ground that the issue involved in the earlier writ petition 189 to 199
Yes.
of 2022 and the present writ petition 317 of 2023, Your Lordship,
Yes.
the issue involved is the same because what the court is to examine is the legality and validity of appointment made without advertisement. That is the only issue. So that is why I have made that concession without filing any affidavit in opposition that the issue involved in both are the same, Your Lordship. So by making and admittedly, even the appellant themselves, they are not disputing the fact that they were appointed without advertisement. So by making that concession, Your Lordship, no prejudice has been caused to the appellant. That is.
Yes.
And in fact, what submission I have made, Your Lordship, my senior counsel has taken Your Lordship to that paragraph 5 of the impugned judgment, which is at page 388.
Yes.
That is which has been read by another single counsel for the appellant, Your Lordship. And that is my only submission, Your Lordship. As the issue involved were the same, I have made that concession.
Okay. Mr. Sanktam, perhaps you'll be endorsing this submission of Mr. Jamir, I think. Madam, two main you have to answer, which Mr. Jamir has tried to raise. Your conduct before the writ court, number 1. Your conduct, specifically if we require your response, are on 2 issues. 1, 2 of the petitioners, they did not even consent to file the affidavit, number 1. Number 2, the concession given on behalf of the present appellants, there was no such instructions to give the concession. 2. Second one is not very important. First is important because it raises the issue of a sanctity in a writ proceeding. Writ proceeding is a court of equity, so your conduct has to be it has to be bona fide. There cannot be any scope of anything else.
Should not be only clean hand, but with a clean heart.
Clean heart.
Clean hand, clean body, clean heart, Lordship. I will. Lordship, this is a very peculiar situation. In fact, I'm very, before going into the merit of the case, I would like to relate to my lordships that on 23rd when I...
you have respondent numbers?
All the respondent numbers, private respondent.
The numbers?
Seven here.
In the writ appeal.
From 6 to 20. They were the petitioners. Now what has happened is, as the case progressed, Lordship, I would not like to...
But Mr. Jamir has said there were 15 writ petitioners, 2 did not give consent. Oh, 6 to 20.
I'm coming to that. I don't know.
Okay, 15.
He did not say which petitioners. But what has happened is...
Let's say that.
What has happened is, there was an outside influence. What has happened is, I was very shocked on 23rd, just on 23rd, before the Honorable Division Bench at Gauhati. I was threatened over the phone also that if I don't take out their name from before, I don't take out their name from the petitioners list, that was also over the phone, I was told. So, and in fact, after the proceeding there, in the constable case also, 2 contempt petitions are pending. So I have to take their consent, and I did all those things. What has happened is, now in the writ petition, in the present writ petition, only few are surviving. Why? Because they have been influenced and they threatened to take out their names from the writ petition, from the petitioners list. So I did that. And in the constable case, only 8 of them, only at the Kohima, only 8 of them 8 of them stood till the last, Lordship, out of 28. These things are happening, Lordship, and what has happened, I was so shocked. So only 8 for the respondent in the 12 writ petition, respondent in the writ appeal. I was very shocked that they engaged another advocate in order to prolong the case. Those others we have left out of 11. They engaged another lawyer and submitted before the court that give them time to file their wakalatnama, to let them present their case. Although I was there and the writ petition I was presenting. This is how, I won't say much, Lordship. I don't want to.
Let us know, let us not go back to what has happened.
So
Can
that
you
is
respond to what
so-
Mr. Jamir would like to end us this?
Yes. So in that aspect, what they are saying is, and their signature is there in the writ petition. In the previous, when we started, it started in 2020, this case. It started in 2020 for the first time in Nagaland against the backdoor appointment without advertisement. This is the first time in the history of Nagaland. So it started in 2020.
Yes.
Lordship, when it started, we filed a writ petition when they were about to go for screen test in 2020. Right after, when they were about to be screen test, we approached this honorable court for staying the screen test. Screen test. Then this honorable court instead directed the petitioners to annex their appointment order and to approach this honorable court. So then I have, yes, that is writ petition number 108. Just a background, Lordship, in order to.
Madam, this will not be necessary.
Okay.
We are answering only the questions raised by the appellant.
So that is the way I don't.
You answer on the aspect of bona fide requirement, bona fide on the part of the petitioner. You answer on the illegal, irregular aspect. And you answer on Rule 8, which does not specifically mention of having a recruitment process. Only three. People.
Let me clarify this in the first place. Why? First clarification, because it's very vast. I am confused with all those things, but just specifically.
It looks very big and vast. The issue is nothing.
Yes,
It's very
it is
small.
nothing, but the way it has gone
no.
round and round and round.
No, it's not gone round. We have now zeroed down.
The question here is why the respondent number 44 and 45 in this writ appeal names were deleted, because there was advertisement. And they are alleging that we implemented them, though they were, that is how the defective is the writ petition in this manner. We filed RTI and for 2 years, they did not give us the appointment orders, and it is through the RTI, they gave us, these are the backdoor appointees, and they gave us, and that's why we never know that their post was advertised. So when we filed this writ petition, these two, 44 and 45, even on the face of record, Lordship, why their names were deleted in the judgment order? Because they were recruited legally, and they came for clarification and review number 4, 2024 was filed before this honorable court. We did not know, because it is the department, for 2 years. Even the previous DGP, he came as the petitioner not to give the appointment order after the State Information Commission directed them to give the appointment orders. Lordship, it is a long battle starting from 2020.
Now, for those two, it's fine. But what about those two, Dave, who have not consented, did not consent?
That's why. Who are they that we don't know? But in the first place, this writ petition was filed by under the authority of Naga Tribals Union. They were the backbone. Naga Tribals Union, Chumkidima Town. They were the one who approach us, Lordship, giving us the name list. Naga Tribal Union Chumokidima, Lordship. They were the one who initiated this, because when
But
This-
are they a party?
In the first writ petitions, they approached this honorable court with the data that the police department gave. They also, as a petitioner, approached this honorable court. Writ petition, when it first started, Naga Tribal Union Chumkidima Town and 28 others. 28 others are the petitioners.
What is the writ petition?
Writ petition number 108/2020.
What is the writ petition number?
Writ petition number 108/2020. So this writ petition was first filed by the Naga Tribal Union Chumkidima Town, since the training center, police training center is at Chumkidima and in Nagaland. This training center is under the jurisdiction of Chumkidima village. They stopped this training and they immediately approached this honorable court in this writ petition along with 28 other unemployed youths as petitioners. That is the first case when we started. However, as I have stated, this honorable court asked the petitioners to annex the appointment order. So immediately after that, we filed RTI on 11/2/2020 to furnish information on recruitment and appointment of constables. Instead, the PIO furnished the biodata of 934 constables in data format. This in the constables. Now, again, another RTI was filed, but PIO rejected the RTI, furnishing the appointment orders. Then appointment orders of constable stating it has no public interest. It is invasion of privacy.
Madam, please,
Okay.
please be concise. We are not on
Okay.
those
Okay.
aspects. We are asking you to first clarify that amongst the 15 numbers of writ petitioners, two have been argued. It has been argued that two of those were not interested to file any writ petition. Their names have been inducted as petitioners without their consent. You were representing all the 15.
Yes, that was their claim, no chief.
Okay.
But when they started threatening me, when I clarified from the Chumakitima Tribal Council, because they were the main backbone, they sent me all the Bakalat Namas. It is
Your answer is that they were pressurized to withdraw their.
Of course, Lordship, of course. And now this time they came to say that we want to represent ourselves on 23rd. I was very shocked. These are something to do with the situation of this case.
But these two petitioners are also the petitioners in the case which were heard in Gauhati Principal Bench.
Yes, yes.
Constable case, you are also the parties.
No,
No.
not at all. The case which has been filed in the Apex Court and the Division Bench in the Principal C.
That is
Constable's
case.
Constable's case.
Yes.
These two are new here. That is why I'm submitting from the very beginning that these two are totally different. Their case is different, our case is different, but relying on the judgment passed in the constable's case, this case was decided.
Lordship, I'll just clarify before the Honorable Court. Amongst the 28, there were BA graduate, law graduate also in the first constable case, and those who are class 8 pass. All together were in the constable case. Now, when we want to file this for the UBSI SI, the education qualification is B only. So from there, we took out those who are graduate and graduate. They became the petitioners in the.
They're the same people.
Same people, same people. And these same people again, I don't know whichever. Anyway, they are the same people who were in
same people in different petitions.
In all the same people in all the writ petition. Only this 28. So the first started 108. After that, 142 was filed. After that, writ petition 39/2022. Till the 3 were filed prior to filing of this bunch of writ petitions. 3 writ petitions, Lordship, prior to 2022. And ultimately, when this Honorable Court dismissed the writ petition of the then DGP who came here as the petitioner, that the appointment orders will not be given under the, when the CIC State Information Commission directed them, this honorable court dismissed his writ petition. They say that it's invasion of privacy, no public interest. So only after that, they gave the appointment orders. And then we started with all this lodge. It's a long battle lodge. For 22 years under RTI, appointment order was not provided. Petitioner consented and signed the Bakalat Nama in the writ petitions. And as such, they cannot, at this appellate stage, say that they did not consent to be petitioners in the writ petition lodging. 28 started. And this amongst the 28 are who have the qualification, were segregated as the
Okay, then you can answer the second question. First, we have, he's saying that taking the cue of Rule 8, he is trying to make an argument
Lordship,
that there is a difference between illegal and irregular. This
No.
at best would be irregular,
Lordship,
and therefore those can be cured and rectified.
no, I vehemently object to that. Lordship, the law of the land is very clear, and I will go by the Constitution, Article 13, Article 41. First, I will raise my case on that. Just
Articles
Article 13.
13.
41.
13 and 141. Article 13 says, law inconsistent with or in derogation of the fundamental rights. All laws enforced in the territory of India immediately before the commencement of this constitution. 13,
Yes.
I'm reading 13, Lordship.
Yes.
All laws enforced in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. So that will cover even the administrative notification also, that in 2014 also they were saying that, see, administrative action is to supplement the rules, supplement the law, not to supplant it, Lordship. So that is impeached. Then 2, it says the state shall not make any law which takes away or abridges the rights conferred by this part. And any law made in contravention of this clause shall, to the extent of the contravention, be void. So, be void. So, can police manual or any other rules or whatever overrule the law of the land, the law of the land authority, as well as the Constitution of India? Now, next. Constitution, Article 141 says,
Yes.
law declared by the Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India.
Yes.
So this is constitutionally, I raise my case on this. I am not on any other issue, but
How do you expand your
yes, I'm coming
on
to that. I'm coming
141?
to that.
141 stare decisions, we know about it. And then which
Irregularity and Lordship. I did not bring today, I did not bring this Uma Devi's case, or that is the law of the land. Even even the public has come to know of Uma Devi's case. Now what has happened is thereafter, Lordship.
you contended these are illegal appointment, not irregular.
Yes, Lordship, why not? Because after they were appointed in 2018 and 19, in between, just 1 year. Imagine how much prior also it has been appointed, but this is the only one particular year that have been under challenge before this Honorable Court. Now and again, the Honorable Supreme Court has already clarified to the High Courts, Honorable Courts, that State of Karnataka versus ML Kesari, that was the first clarification who Uma Devi clarified. It is very specific before this Honorable Court. Uma Devi says 10/4/2006. Prior to that, those who were irregular, the cutoff date is 10/4/2006. Where is in the law? Show the law where it says after Uma Devi's case, keep on making irregular appointment, and after reaching 10 years, that is also 10 years. They are only 4 or 5 years. At the time when they started, we challenged this. It is a continuous litigation lordship proceeding. So where is in the law of the land that after 10 years, keep on appointing irregular appointment without advertisement? Is there a law? Now in this, so 2009, 2010 SCC 247.
Which one? ML Kesari?
This is in LM Kesari's case. Yes,
Citation, please.
2010 9 SCC 247.
Para?
Para 10 in 11 lordship. I have some citation that is very relevant and the latest one, but since lordship, to my understanding, any appointment without advertisement is void ab initio and non as in law. So where is the question? Who can change that? And they submitting all the whatever they are submitting before this honorable court cannot change the structure of the case of being here. We are only before this honorable court on advertisement only, nothing else. Was there advertisement? In none of their pleadings, they have pleaded before this honorable court that yes, there was an advertisement, and we are only approaching this honorable court. Our issue is only on advertisement, whether there is advertisement. If this honorable court says that even if there is no advertisement, it is legal, that is another thing. But it is known as in law. It is void. Where is the question of giving them relaxation? This honorable court was considerate enough to give them relaxation of age. That I also subscribe. That I also subscribe and say that relaxation of age can be given. But when the appointment is known as in law, void from the beginning, where is the question of giving other relaxations, lordship? That will perpetuate illegality, lordship. Now, so Uma Devi clarification in Kesari's case is very clear. It is prior to 10/4/2006. Those who have served 10 years in irregular posts, all the state were directed to give them regularization in a irregular. That is very clear, even if I don't submit before this honorable court, lordship. Then in 2018, 8 SCC 238.
2018,
8 SCC 2038.
238.
238, lordship, I beg your pardon.
Para?
Para is 6789.
What is the name?
This is Narendra Kumar Tiwari versus State of Jharkhand. Here also, second clarification on Uma Devi, cut-off date, lordship. Because some states started adopting that 10 years cut-off date. So there is no question of appointment done after Uma Devi and after irregular appointment and after 10 years regularization. Here, in this case, in Narendra Kumar Tiwari versus State of Jharkhand, State of Jharkhand got statehood in 2000, lordship. They continued irregular appointment without advertisement. And so the Honorable Supreme Court quashed all the appointment orders and directed the State of Jharkhand henceforth to continue to advertise all the posts, then to make appointment. Without appointment, State of Jharkhand, after they got statehood, started making appointment irregularly.
Okay.
So that is clear.
Okay.
And my lordship, with regard of they saying that they have served 4 or 5 years, although it's not the need. However, in my lord will kindly see that in 2014-13 SCC 232, That is state of Bihar versus,
What is this ratio?
this is ratios termination after 15 years.
Okay, 2000?
2014, 13 SCC, 232. Length of service, without, it's immaterial.
Paragraph,
Just that
paragraph.
length of is 8, 9, 10, 11, 13.
8, 9, 10, 11, 13. State of Bihar versus Chandreshwar.
Chandreshwar Lodge, Pathak. This termination was done after 15 years.
Not interfered.
Not interfered, Lordship. That is illegal appointment. Without advertisement is illegal appointment. Irregular appointment is one aspect. Illegal appointment means without advertisement.
There is termination after 15 years.
After 15 years. Also, Lordship, in the 2005 for SCC 209.
Same ratio.
Same ratio.
That's okay.
Termination after, yes,
Okay,
Lordship.
they're not-
Anyway,
Yes.
then my lord will kindly appreciate that why the two other respondent 44 and 45 were deleted from their writ appeal.
We have already answered that.
Yes.
In your RTI, you did not get the information for 2 years.
Yes.
You included them, then they came up later with a review that they were appointed after advertisement. Clarify.
Lordship. And with regard to police manual, my lord will kindly come to page 365. It is clearly already decided in paragraph 29.
365.
365, paragraph 29. All this has already been discussed.
Paragraph
29, Lordship.
29.
29. Page 365. It talks about the police manual. Taking into account that issuance of an advertisement or calling for applications from eligible candidates is the mandate of Article 14 and 16 of the Constitution for filling up vacancies of employment under the state. The necessity, therefore, is that in order to make Rule 20 of Part 3 of the NP Manual in consonance with the provisions of Articles 14 and 16 of the Constitution, the aspect of having an advertisement or inviting applications from eligible candidate has to be ingrained to Rule 20 of Part 3 of the NP Manual. Under such circumstances, this court therefore in order to save Rule 20 of the Part 3 of the NP Manual from being constitutionally invalid, has to read the necessity of issuance of advertisement or inviting application from eligible candidates as being ingrained in Rule 20 of the Part 3 of NP Manual. This is already discussed, Lordship, so there is no confusion to it. I have other citations, but Lordship, this is the latest one, my lord, SCC 2025 SCC online, SC 280.
2025.
SCC online, SC 280.
Amrit Yadav, what is this?
Paragraphs?
Paragraphs are 31, 32, 34, 35, 36, 37, 38. These are very relevant. This is the latest one, Lordship. All other authorities have been referred. 31, 37, 38, 39, 41. Also 19, 23, 25, all are relevant, Lordship. Everything is covered here. Shall I read out?
No,
This-
that's not required.
Especially paragraph 21 are very relevant. In fact,
21 or 31?
yes, paragraph 21. Of course, all are very,
21 or 31?
uh,
You said 31 first.
Yes.
yes, Lordship, 21.
21.
Yes, 21 also is there. before that, 19.
No, 21 is only a quotation.
Yes, quotation as
But
well.
where is the findings of this in this case? Amrit Yadav.
Starting from 31.
Okay, that's it.
Yes. This is the latest one that is before this honorable court lordship. Any other clarification that I have to make? Because to me, I feel that the judgment order dated 20 passed by the learned single judge under the coordinate bench judgment order, that 26 on 26 again it was passed. On 26, one was for the 317, and the other one is that exclusive ones they have left out from the RTI list. That was on 23rd we got that, and that was it. This is Lordship, you kindly also reiterate paragraph 5, page 388 of the judgment order. Paragraph 5 submitted by the state government.
Page 388.
388 of the judgment order. 5. The state government has submitted before this honorable court the learned counsel, the respondent number 6 to 45 has also submitted similarly lines adopting the submission of the learned state counsel, and no counter affidavit has been filed on behalf of the respondent number 6 to 45. In this issue, I will just maybe this be the final clarification, Lordship. They are saying that they were not given opportunity, they were not heard. That was their plea before this honorable court on 6/5/2024.
Yes.
In the writ. I will just satisfy my knowledge.
The order 6/5 to.
Yes, yes, in the writ petition. This is the first time they appeared before this honorable court when they say that they have not been given opportunity. This is the first time. That is 6/5/2024.
Yes. No, they had appeared.
Yes, they appeared.
Their
there.
appearance is not disputed.
Yes, but
The only submission which have been tried to be made by senior counsel is that such instructions were not given to give a concession.
in the previous occasion, this was the main contention.
Okay.
So I just, if it is not needed, then it's. And the last one is allowed 3 weeks time. 7 months were given to the opposite party to file their affidavit, but they say that it will be placed under the constable's case. That is very factual. And if my lord will kindly appreciate that I have brought that for the two thousand eight.
Just a minute.
Of course. Lordship, for the report,
Yes.
this is the Supreme Court, because it is similar cases and it is already reflected and it's the SLP that was this is, it should be put on the report.
Yes, yes. Oh, we are not inclined to interfere.
Yes,
Oh, there's a finding.
that way, of course, which. And since that is already done, otherwise 2008-13 SCC 395.
What purpose?
This is advocate absence.
Not required.
Okay, okay, Lordship. That was also main issue, the previous occasion.
Just a minute, please, just a minute.
Oh. Oh. Lordship, this is the one copy that the last page where it has become the order passed on 23/10/2025. The last page where it has already been signed by the Chief Justice. The order passed on 23rd.
No, that has been given, one copy has been given.
But that was not signed by the.
Doesn't matter,
Okay.
doesn't
okay,
matter.
Lordship.
We are
Because
not.
because what has happened is, Lordship, this case was kept pending on 16/7/2025, even without hearing my status quo IA to vacate the status quo. It was kept pending on 16/7/2025. And thereafter not listed because they submit before this honorable court, it should be placed under the outcome of the IAs and writ appeal pending.
Doesn't matter, we'll
Yes.
not go back to those.
Lodge.
Those are all over now.
That's why it was listed only.
How pen rakhi banane ke kyo pen rakhi? Dikhana hai. Pen le check हुए तो ना red लगी. Pen check करे के ना रखी बोले. दिखाना था ना. Yes, okay. Okay, we'll try to deliver as soon as possible. We'll reserve it. Because my brother will be leaving tomorrow. We'll try to deliver tomorrow itself.
Place some judgment.
On which aspect?
On the left side and about of the council, there is one.
That we have already,
And
we have
then
already seen. You have placed 1981 to STC 788.
And then the
We have seen.
session,
We have seen.
2003.
Those are here in this record. We'll take care of those.
One IA has been filed in reply to the submission of my learned friend. Status quo order was passed on 13/11/2024.
Yes.
13/11/2024. That is the status quo order passed by the Honorable Court. And it was made absolute on 27/11/2024. Now, subsequently, they have filed an application, IA.
Yes, those we are not going, we have heard the entire matter. We are not only whether we extend the status quo or not extend.
But
We are deciding the writ petition.
that is on the ground of maintainability of the writ petition. That is why it comes to the fore of, first, it has to be decided whether the writ petition should be maintainable.
No, you have already addressed, we have.
And that some facts I have not pointed out because in the application, 3 persons have not filed, have not joined in filing the IA. They were also not.
Mr. Jamir, rest assured, we are not saying anything on the IA. IA, the status quo has been made absolute at the subsequent stage. We are now deciding the entire petition.
What I'm trying to project is, Lordship, by filing the IA, 3 petitioners, 3 respondents, they have not filed the application. They have not joined. They have not met as per whom a respondent as well. They have not met. Why? Because I want to place one vital document.
Mr. Jamir, we are reiterating, we are not on those. We have heard the rate appeal on merits. Yes.
How we have held the writ petition. Don't technically consider that. I will conclude with that, Lordship.
Which one?
That is up to the judgment in the constable's case. Up to the order was passed. And whatever my learned friend has referred to are all with regard to the constable's case. And the present date appeal has been filed that there is a basic distinction between the constable's case and our case.
Lordship.
Before you could file the SLP, we have already filed the writ appeal. SLP was filed much later by the constables. and we have nothing to do with that.
Correct,
It's
correct,
okay.
correct, correct.
But the principal, Lordship, two persons not joining in, those who were asked to be out of the.
Those who have been selected those who have been selected,
No, no, no,
the
no.
other two.
Yes, two were excluded because two were excluded.
Yes,
Because they were
Yes.
advertised.
Yes, that too, yes.
Yes,
That shows how much communication kept there between the council and the client. The client did not know that he is fighting a case by the council.
it's okay, they are not before the sun.
Okay,
And this is not an
yes,
isolated
hard,
case.
hard, huh? Hard, so on, okay, get the names of everyone, huh? The hearing is concluded, judgment is reserved. Okay, thank you.
Highly obliged to.
People are here, I'm gonna leave it, so he don't.